So greetings, good morning. You're now listening to Chief Rock's YouTube channel and the SoundCloud here, and we're sitting again here in a part two of our interview with Winston Shrout. Now the first part went really well. We're just doing a follow-up with Winston on a lot of the different aspects of commerce and Admiralty Law and contract law. Winston, how are you this morning?
I'm doing just fine. How about you?
I'm good. It's we're here on the West Coast. It's Pacific time, and I'm not as tired as I expected to be at 9 in the morning.
Well, I'm an early riser, so
Yeah, I'm a night owl, so sometimes I'm up to like 2, 3 in the morning. So
oh, no good at all. You need to go to bed when the sun goes down. Of course,
so
I guess you young folks are a little bit better suited to that than some of us old timers.
yeah, going out. I'm a music artist, so
Oh,
yeah. Oh, you
what
didn't know that?
what
Yeah,
kind of music? What kind of music do you do?
I take my traditional Haudenosaunee social music, and I've been putting it over top of like electronic hip hop sort of beats.
Okay.
Yeah, it's a really good hybrid of music, and it's been very well received lately amongst a lot of the uh, music goers that I've been doing shows for, and I've been performing for fashion shows, and
Well, great. You
yeah,
know, I do my native traditional music too. It's called bluegrass. That's what the hillbillies do back in the mountains.
you play something?
I play a little bit of everything.
Oh yeah,
If you go to our, some of the seminar DVDs and different things that we've
I
produced.
hear that. Yeah, I heard all that music. Yeah,
Well,
was
yeah,
that you?
that's yeah, a lot of that is stuff that we've co-produced. Me and the audio guy, he likes to play mandolin pretty good, and I back him up on the guitar. Sometimes, even one of the seminars, we featured dulcimer music, which of course is traditional Appalachian, type music and so forth. So yeah, hey, I'm into the music end of it too.
Hey, that's good. That tells me that both sides of your hemisphere, your brain, or you're using them, right?
Absolutely.
Plus, I used to be a welder. I used to be a construction guy
Oh
working on
yeah,
yeah. So and you come from that kind of background too.
yeah. I've welded up a lot of steel.
So we have a lot of the same background now. It's great.
Hmm.
So the one thing I did have we wanted to get into is maybe touch on a little bit of UCC again, maybe in regards to some sort of enforcement. I know we spoke about getting a certified copy to bring into the court
Hmm.
and perfecting your lien on I guess property because it has to be registered in order to perfect it.
Hmm.
Um, just maybe because I mean what's happening is a lot of the people from at least what I'm gathering is they're not sure what to do. They don't know what to do. They've heard about this thing called a precipice, where you don't even need to go in front of a judge. You can get a writ or an order written up, and
Uh,
the
yeah,
foreign.
that actually goes back more to the common law concepts. If you want me to, I can give you just a bit of a history that might be helpful to people to understand, what has been in the past and the situation that we're operating with at present.
Oh, please, yeah, that'd be great.
Well, basically, it has to do with the nature of money, and that is, the nature of the money that we use in commerce has changed considerably since around 1933. Certainly by 1935 and 36, all the countries on the planet had gone into bankruptcy, and then the reason for that was so that they could basically do international commerce. Debt currencies were certainly introduced, and so the money situation changed the nature of the commerce, and it also changed. It also necessitated, a change in the law form that we go by. So over a period of time, I mean, prior to that time, there had been inroads made, or certainly since, well, for instance, in the late 1800s, they passed what was known as the Negotiable Instruments Law, and so they started operating on those levels already. And then after the 1930 period of time when there was a change in the money, then eventually they came to the adaption and adoption of the Uniform Commercial Code in order to resolve any disputes that might arise in commerce. So I think probably a knowledge of the change in the money is instrumental in understanding what we have today. Now, with the change in the money and the country's operating from a bankrupt position, that basically did away with the common law on the basis that it's impossible to execute a contract. People have to understand that a contract does not exist where it's made. That contract exists when it's executed or paid. And so if you can't pay a contract, then the contract itself is not a contract. It has to evolve into a different form.
So that would make sense in regards to that. All the fiat currency being used isn't real money. I mean, it's a form of exchange, but you're not really paying anything because you're using a debt to pay a debt, essentially. So one of the words you have to take out of your vocabulary is the word pay. You can't pay.
You can't pay.
Yeah, there's no pay. Yeah.
The only thing you can do is adjust the account. And so that's been the whole emphasis on our education process over the years, has been to teach people how to properly adjust their accounts. Now, we do have a problem in as much as, since we've gone to public policy and the common law has gone away, so to speak, that we do have a few misunderstandings about what we call money of exchange and money of account. And that is, we do use from time to time money that has equity attached to it. For instance, when you go in labor and you exchange your labor for a currency such as Federal Reserve notes or whatever kind of money it is you're using in Canada, there is equity that attaches, to the actual money that you exchange for. So it's how you use that equity money. And I'll have to say that once properly understood, then the people will stop being robbed of their equity by the processes that are being used. And that is that in all of your public doings, for instance, taxes, mortgages, or anything that appears in the public, which is not strictly a private dealing, then money of exchange is not required. The only thing that's required is money of account, or the adjustment of the account, if it's necessary to use negotiable instruments such as notes or drafts and so forth. That's okay. But there's no equity that can attach to a public debt, and people are being fooled into believing that they have to give up their labor in exchange for a debt that only requires an adjustment or settlement. So people are getting ripped off.
See, I have a document. It's a notice of tender for set-off. And it's more, what we're doing is I had quite a few clients who took the statement of account, they would write accepted on it, sign it, date it, and then turn the bottom part into a money order, and then tender it back to them, saying, here's your document back, and we're accepting the credit, because all the documents all have positive numbers. There's no negative numbers showing that you owe something. It's always a positive showing a credit. And so they accept that credit, tender it back for set off, and these people steal the vouchers all the time, and they never ever honor any of the agreements.
well, then they need to be sued in court for recoupment. Let me explain that a little bit further. This is the basis, for the problem is that a system was put in place. For instance, here in the United States, it first was authorized under House Joint Resolution 192, and then I think Queen's Council, or what do they call that situation in Canada? What's that? Do you remember the name of that act? Queen's Council and whatever it is. Anyway, it had the same effect, and that's the basis for what we're doing now. Really, to completely comprehend, and I don't think we want to go too deeply into this because it might confuse people a bit, but certainly the understanding between the difference between an open account and a closed account is technically essential. For instance, when we do an acceptance on an open account, well, in essence, what we're doing is we're closing that account, which means the interest, stops running on that account. And once the interest stops running, then we go into a settlement, and the settlement again has to do with money of account or adjustment and so forth. And so people are getting tricked into keeping the account open by tendering money that has equity attached, and that's completely backwards. I mean, it's actually illegal here in the United States. That is illegal. But the banks, the mortgage companies, the government agencies get away with it when the people are uninformed and don't come back and demand that they comply with public policy and so forth.
The thing you're looking for was the order in council.
Yeah, order in council.
Yeah, that's what you're I guess you're referring to.
I can't remember all those names.
Yeah, order in council 16.
Yeah.
Yeah. Yeah. So it's illegal down. And you know what? And down in the United States, and I know, and I think we spoke about this before, that Canada is registered with the SEC, which I guess would. Some people say that doesn't matter. That Canada is it's a Commonwealth country, and United States is not.
Well, the word Commonwealth, if you go back and study it, it traces right back into history, right through England and back into the Vatican. You understand, back in the 14 and 1500s, the Vatican created 3 sesticicae trusts, and from that, that's where a Commonwealth stems. Commonwealth, I think, also has close ties to the feudal system. Now, for instance, the state that I was born in was called the Commonwealth of Kentucky, and that's what it was. It was a Commonwealth also in the beginning. But then as things change, certainly as the form of money changes, as the public policies and so forth come out, then the effect of a Commonwealth probably is negated because of the money and how we use it.
Yeah.
So in practical terms, I mean, whatever you want to call, a government or a political institution and so forth, you can call it what you want, but then you have to investigate to see what's really going on. And then once you see what is really happening, then it don't make any difference what you call it.
Yeah, and as you speak about investigating, there was a gentleman who was hired by the Canadian Army to research and find out who Canada's future threats could be.
Mm-hmm.
In his research, he comes to find out that the Canadian courts and the local police are the actual enemy of the people, of the Canadians. And
absolutely.
And there's corruption, there's coercion, there's colluding, there's all kinds of conspiracies going on within the lawyers and the police officers. And so he started reading more about the Admiralty world that's actually going on. And what he did is he actually stop paying his mortgage to see what would happen. And he, he kind of did a bunch of stuff, and basically, because he knew that the original note that he signed to get his mortgage, after his research, he started finding out that they sold that on the securities market. So they'll never be able to produce the original, and those who have paid it off have never requested the original back after they paid it off. And basically, he went into court and presented all his evidence, and he found out that a lot of the courts in Canada are taking those court dockets, and they're taking it to the Minister of Finance here in Canada, and then they're selling it on the international market, all the court cases.
Yeah, I think that'll probably come to an end, though. Here in the United States, you understand, people have to understand that when a complaint is filed, it's always an assumption of debt. And when an attorney files such a thing into the clerk of the court, and you have to realize that the court is only a bank. Anyway, when that complaint or that criminal indictment is filed with the clerk of the court, it is in fact a negotiable instrument, and the attorneys are simply using the court as a third-party debt collector on that instrument. So the question always comes in regards to a complaint or an indictment is who is going to be the payor on that indictment. In other words, who's going to pay that assumed debt? And so, some of the technology we use, is to break down the assumption of the debt, or if we want to go ahead and let the debt turn into a presumption, then we go into various vehicles that can be used to adjust that account. Because what the courts are trying to do here in the United States and all over the planet what they're doing is they're taking in an indictment or a complaint, which is a chosen action, and they're making a summary judgment on that instrument, and then demanding payment in specie. So the courts are guilty of conversion of a non-security. And so these complaints and so forth that come across, are being converted. It's illegal. They're being illegally converted, and the judges are demanding that the defendant pay in specie, or what we would call money of exchange that has equity attached to it. Now, the reason they do that, of course, is so they can steal the equity and labor of the people. So we're trying to bring an end to that.
And what's going on to do that? What do you, when you say bring an end to it? What steps or what background stuff is going on?
Well, it has to do with dealing with the courts and so forth. Right now in the United States, and I would have to suppose in the courts in Canada and other places, there's what's called a sequester. And that is they're having to readjust how they're doing things on the basis that, that what they have been doing is unlawful and fraudulent, and it has to be brought to an end. And so at this point, I think they're measuring what can be done to change that system and turn it back into what it was originally designed for. And again, here in the United States, a lot of that has to do with the demise of the Federal Reserve banking system. The U.S. Treasury is working to reestablish, the functions and so forth. But you have to understand that, the biggest problem that we've faced across the planet is the problems caused by central banking. And so when those things are resolved, when we get the banking resolved, and there's a lot being done to resolve that problem, but when the banking is resolved and the banks are required to follow their charter, then you'll see the same changes and so forth happening with the courts. I'll give you, for instance, here in the United States, the complaints and indictments and so forth that came in, as I mentioned, are negotiable instruments. And so those negotiable instruments, if they're not paid by the defendant or by a representative for the defendant, they go into a dishonor. And so those negotiable instruments / complaints are dishonored by the defendant or by the trustee / surety for the defendant. And in consequence of that, they take those instruments to the federal window for funding. And they do that, in our case, to the county comptrollers. So let's say a complaint comes into a civil matter. The defendant comes in and starts to argue about it. Now, see, this all goes back to bankruptcy again. Maybe we can explain that so people understand it. But in any event, a instrument comes in a civil or a criminal matter into the court as a third-party debt collector, and then the defendant argues about it. That creates the dishonor. And so then at that point, then that delinquent creditor who argued about it is now subject to liquidation through involuntary bankruptcy. And in essence, that's exactly what happens when the negotiable instrument / complaint is taken to the comptroller of the currency. They simply present that at the federal window for payment. Now, we do the same thing to them. I mean, don't get me wrong, it's not a one-way street. I mean, when we do an acceptance for value and they dishonor that acceptance, we go through the same process, although we're not using the county comptroller.
Yeah, that's the thing I was going to ask. Well, before we get into that, before I ask what we are using, maybe you could go back into explaining what you say it goes back into bankruptcy, and you wanted to maybe go into that a little bit.
Okay, yeah. As I mentioned, since the adoption of a debt currency such as Federal Reserve notes, you understand that the Federal Reserve notes are the reserve currencies, and all other currencies are measured against the Federal Reserve note. And so in consequence of that, all the currencies across the planet are debt currencies, because naturally if they're measured against a debt currency such as the Federal Reserve note, then they have to be debt currencies also. Now,
Right.
This was a result of the bankruptcy of the United States. First off, the United States has always been in bankruptcy, but up to 1933, they were operating with substance-backed currency in that respect. But in any event, as things change, as circumstances change. Now, let me state right here, I'm not against that happening. I'm not at all. It was the only way that we could have accomplished what we have today. But in any event, getting back to the subject matter here, and that is that the United States began to operate what's known as a Chapter 11 reorganizational bankruptcy. Now, a Chapter 11 reorganization is an interesting animal, inasmuch as mentioned, it's a reorganizational bankruptcy, which means, it's not a liquidation, it's simply a reorganization so that the company or the corporation can continue to do business as usual without the interference of the creditors as in a liquidation, as in a Chapter 7 liquidation style. So, as a result of that Chapter 11, you have to understand that whoever files a Chapter 11 is known as the debtor in possession. Now, the debtor in possession operates in the reorganization as if they were the trustee. And as long as the debtor in possession operates the reorganization correctly, they will remain as the functional trustee in that Chapter 11. Now, for instance, in the United States corporation filed for Chapter 11 became debtor in possession. So, when the debtor in possession sends out a request, now let me just stop right there. You have to understand that all corporations are joined at the hip. For instance, we have the United States Corporation, We have the state of Kentucky. We have IBM Corporation. We have Department of Justice, which is a corporation. Anyway, all these corporations are the same corporation because the mother corporation just simply authorizes these baby corporations, but every corporation is simply a subset of the United States corporation. Period. So,
but isn't there a difference in the type of corporation? Like one's a legislative corporation, and so all corporate, no matter government or business, it's all the same kind of corporation.
Are they all written in capital letters?
Yeah.
That's the end of it.
Okay, and who are they registered to? The United States and Canada. Who's the mother to them?
Probably the Crown of England. I say probably because I can't say for sure. But for instance, the United States Incorporated is actually a maritime corporation registered in Puerto Rico. So they've gained control by whatever means. But in any event, what we're trying to get to here is a demonstration of the debtor in possession and how they act in the Chapter 11. So the debtor in possession then, when the corporation needs money, who do they go to? Do they go to the priority stockholders or do they go to the common stockholders? So if you know anything about a corporation, you know that the corporation raises capital by taxing the common stockholders. Now, the common stockholders in a debtor-creditor relationship are, in fact, creditors. And so the debtor in possession, when they need to raise money for the corporation, they go to the common stockholders / creditors and request the money. Now, if the creditor / common stockholder refuses to give the money in whatever form, then that creditor becomes a delinquent creditor, and they can be taken into involuntary bankruptcy and liquidated for the amount of that dishonor. You see. So when the United States, goes to the common stockholder and says we need $1 billion over here for this or $1 trillion over here for that, they simply just go ahead and do it and then put it on the back of the people as the what they call the national debt. Of course, it's not a national debt, it's a federal debt. But anyway, they use the device of the Chapter 11 bankruptcy to accomplish that. Does that make any sense, or does that raise more questions?
Yeah, I mean, it starts to raise a lot more questions, and I guess the first thing that came to mind without really fully hearing your explanation was, in possession of what exactly?
Say again?
I mean, the first question that came to mind when I heard you bring it up, when you said debtor in possession, it started making me think, well, possession of what?
Well, that's the title of the particular position. People misunderstand bankruptcy, from that. Hey, could you hold for just a second?
Sure.
Okay, sorry, I'm back. Can you hear me okay?
Yeah, I got you.
The term debtor in possession may be misleading. People have to realize, when you get involved in the public and everything, everything is just backwards of what it sounds like. Now, for instance, a bankruptcy itself, the purpose of a bankruptcy is for the debtor to discover the assets of the creditors. That's why the creditors have to file the proof of claim, or what's called a B-10 form. And so bankruptcy, is backwards of what people think. And so when you start to talk about a bankruptcy, the question arises, who's actually in control of the bankruptcy, the debtors or the creditors? And the answer is the debtors are.
Huh. Interesting.
Yeah, you have to rethink. You have to rethink things because it's not always as it seems. So in regards to the Chapter 11 reorganization that the United States is operating as a Chapter 11, the question arises is who is the controlling party? And the answer is that the debtor in possession is. And so when they go to the common stockholders / creditors with a request for money, and the creditors don't supply that to them, then they go into the liquidation phase. Now, this is the basis of why accepted for value is so important, because in essence, when an instrument, or when what under the UCC is called an incomplete instrument, is sent out to one of the creditors or one of the common stockholders, in essence, what they're saying is that we need this amount in this account, for the adjustment. And so, if you oppose that, then they'll go ahead and go into the liquidation process. And so, we don't oppose it; we accept it, which closes the account, which stops the running of interest. And then we give them the use of our exemption as a pass-through for settlement on the transaction tax. You understand that in the system that we operate with, it is a benefit privilege to be a part of that system. It's not a right. You see, it's a benefit privilege. And for every benefit privilege that you participate with, there's a tax that's required. In the case of financial transactions, that's called a transaction tax. And so, when there's any kind of a incomplete instrument that's sent to you, and so forth, the completion of that transaction, there's a tax that's attached to it, and the accounting company or the agency that handles that is the Internal Revenue Service, or the what you call it in Canada. It's the same bunch, but anyway, they're the ones that hold the accounting on all those transactions.
That'd be CRA.
Yeah, CRA. And so when we start to do acceptance for value, and a while ago you mentioned someone that had used an acceptance technique. Certainly, I would hope that they had supplied their exemption for the pass-through Treasury Direct, so that the transaction tax, could be settled using the exemption. And so that's how we settled and closed things.
Yeah. See, I my thought on that was, when we did it, reading a lot of their bills of exchange, that merely just writing accepted and signing was all that was needed, because they had the pass-through account already as to how they're even able to access the credit to even offer it. That, if that makes any sense, like, a lot of these companies already have your social insurance number, or your SIN number, so why provide it again if they've already?
Because maybe you need to authorize them the use of that exemption for the pass-through. They may have. First off, it's not your number.
Yeah, it's not our number for sure.
That was the point, I think, of the discussion we had prior, when we had another interview, and that is the use of the UCC1 financing statement to take control of that number.
Yeah, we actually didn't get into that, of taking control of that number.
Oh, I thought we had.
No, we just discussed the filling out of securing property and the basics of the UCC1. We never actually went in to the actual UCC of securing the birth certificate, bond, or the SIN, or the driver's license.
All right. Well, just real quick, you can use a UCC1 financing statement to take control of that number, because no one else has filed on it yet. And so routinely, when we do a UCC1 financing statement, we include that, what people call in the States a social security number, what you're calling the social insurance number there in Canada. So we put that on the UCC1 financing statement. So we have a claim on that number. But even if you didn't do that, you still have a proprietary right to the use of it because you're the party that signed as the surety on the account that produced that number. So from strictly proprietary position, you still have control of it. We just do the UCC one to further that. But in any event, we don't want to get back onto the UCC financing statements at this point. Perhaps we could a little bit later on.
Okay.
But in a nutshell, that's why we would do that. In any event, the permission to use that number as a pass-through is essential to extinguish the transfer tax.
Okay, so merely taking a criminal charge or an original accusatory charging instrument and writing accepted on it and writing your social insurance number would stop that instrument tax.
Yeah. Now let me get a little bit further into that, and I'll have to describe it in the form of a trust. Basically, and this is a foundational concept that everyone should understand. And that is, anytime the outcome is uncertain, there is risk involved, and consequently a trust is formulated. So everything that we're doing when we're using fiat currency, again, we're back to the money issue, you see. Anytime we're using a fiat currency, which is a debt instrument, the outcome is uncertain because nobody knows if that debt's going to be paid or not. And so because the outcome is uncertain in regards to the money that we're using, then every situation that we get involved in the public is in fact a trust situation, you see. And that again is the genesis and basis, for all the things we become involved in. For instance, if you take a court case, when the attorney files that negotiable instrument, at the time of filing, is the outcome of that instrument certain? The answer is no, it's not. The outcome is uncertain as to what's going to happen with that instrument. Therefore, when that complaint is filed with the clerk of the court, a trust is set up. So the real question, that the clerk of the bank or the clerk of the court, as it were, is to basically contact the surety trustee to find out, are you going to pay this or not? That's the basis for it. And so when people say, no, I'm not going to pay it, then they go into controversy, and then under the provisions of the reorganizational bankruptcy, then they get liquidated for that amount.
And so when we're talking about arguing, we're talking about going in and saying, no, I didn't do that, I'm not guilty.
Oh, we never say that.
Well, I mean, that's basically what they're trying to get you to go in and say, not guilty, I'm not going to pay. And people don't even, I try to tell people that they don't really comprehend. They go, pay what? I said, well, it's a charge. Think about it, a charge card, they're putting a duty or responsibility on you, that they're imposing that. Yeah,
but let me finish up with the thought process I was working toward.
Okay.
Which is that any trust that is not indentured is considered to be a sestacavai trust. And so when we do an acceptance, basically it's in the form of a sestacavai. And so we indenture that trust. So in our acceptance language, we put that trust indenture in there, which is, in our case here in the United States, we simply put the indenture on there, which is deposit to the U.S. Treasury and charge the same to the straw man and the straw man account. And so we're indenturing that trust. Now, this goes back to the concept, basic trust law, trust law 101. And that is the intent of the settler is the law of the trust when it is expressed. And so when we do an acceptance, we're going past the assestate vi concept, and we're going into an express trust as the settler. Because again, let's look at my account. I have a Social Security trust account with a number attached and so forth. But as it turns out, I am the only contributor to that account, and therefore I am the settlor. And so when the settlor expresses his intent in regards to that trust, that becomes the law of that trust. So when a complaint goes into a court and the clerk sends a summons and a complaint and a copy of the complaint to me, which is an incomplete instrument, then when I do an acceptance on it, sign the thing, date it, give my exemption number for the pass-through, and then indenture it, which is deposit to the U.S. Treasury and then charge back against the straw man account, then I have completed that trust, and now that is the law of that trust.
So just maybe go back a little bit when you're saying they send you a summons and they send you basically a promise to appear, right, is what you're saying?
Well, a summons goes back into Admiralty procedures. Yeah, they're requesting your appearance at the court. And so along with the summons, they generally send a copy of the complaint of the negotiable instrument, and that copy is only an incomplete instrument until it has an original signature on it. That's why when we do acceptance, we put that original signature on there. And by the way, that reverses the whole court situation, because now once you have accepted that incomplete instrument, now you become the holder in due course. Now, holder in due course doctrine should be studied. It's important to understand holder in due course. It's contained in Article 3 of the Uniform Commercial Code, and I think you can read about that UCC 3 in the 300 series.
Okay, so Article 3, holder in due course.
Yeah, that's an important concept to understand, because here's why it's so important, is that only the holder in due course has any rights and immunities on the instrument. They're the only party that's legally can execute that instrument. Now, when that original signature complaint comes from the attorney to the clerk of the court, the clerk takes it to the judge locks it up in his vault, but he has not reached the status of holder in due course on that instrument because he has not accepted it nor guaranteed payment. Therefore, he has no rights and defenses on that instrument. He cannot execute it. They do it anyway, but that's theft.
So maybe to be a bit clear, so the summons or the promise to appear you get, and the accommodating documents telling you what charge that your person's being charged with, you want to accept it for value, put on your pass-through account, and you want to send them the original, but make a photocopy for yourself, or maybe get a certified copy from notary and send it back to them for settlement.
No. So you only send original back. So when they send you a copy under the UCC, that's called an incomplete instrument.
Yeah.
But your original signature on that document turns it into a firm offer, which can now be dealt with. Now, once you put your signature on that thing, now you become the holder in due course, and then at that point, you have all the rights and defenses on that instrument.
Right, but
anyone else that tries to execute on that instrument is a thief, and then you deal with that.
Yeah, but I'm saying you once you do that, you send the original back to the court.
Yeah.
Okay, and then
Original signature. You can't put anything into the court without an original signature on it.
now do you just mail it to them by regular mail, or are you saying do you attach it
Or
to
you
enter it
take
into the court case?
Yeah, you can go ahead and file. What you would do in most practical cases is that you would file a regular court document. The title of the document would be simply notice of acceptance. And then you might have a few lines in there, and then you might say, see Exhibit A, and Exhibit A would be their copy that you've put an original signature on, then you've put it back into the court. So you either mail it in or take it in, whatever, and get using the normal court procedures. And so that when you file, now listen, when you file that into the court, which is an original signature document, at that point you would request a certified copy of what you just filed.
Ah, so that's why it's important to bring it in person and
usually. And then at that point, with your certified copy, you can go on to the private side and make it a part of the record using the evidence rules. Now, once it gets into evidence, now that's the recordation. That's the finding of fact. That can be leveraged, to get that thing settled.
See, a lot of people are missing that whole step. Once they sign it, they don't know what to do with that, and I think that's the main.
Well, it's too bad that the courts are so dishonest. We shouldn't have to go through that process of sticking the thing into the evidence file and making a record of it. But because the clerks of the courts and the judges and so forth are dishonest, then we have to go through this whole process of putting it into evidence. It should be a normal transaction. They should take that original signature acceptance and adjust the account, reducing it to zero. Using your exemption for the past.
In Canada, a few of the gentlemen would go up and say, "Well, I want to inspect the original charging instrument or the original complaint to see who signed it," and they'll say, "Well, we don't have an original; it's in the computer." So I'm like, okay, well, that doesn't make any sense because the last gentleman, the one I told you about, who went in front of the judge without a robe, they during his trial. They said, well, they have an original charging instrument, but they didn't bring it out for him to inspect. They just showed him a copy.
Well, probably the situation is that they have already sold. See, that's why I say in the background, the courts are thieving. They're stealing. They're selling an instrument, which is a debt instrument. They're selling it on the market or whatever. Or passing it back to, through the federal window or so forth for payment when they have no right to do so. The judge, even with the original in his hand, is only a holder. Again, go back to Article 3 on holder and due course doctrine and find out the difference between a holder of an instrument and a holder in due course. Only the holder in due course has the right to execute on that instrument. And the judges are not holder in due course, yet they're going and executing those instruments with nothing more or less than pure thievery. They're thieves.
Yeah, and these aren't even judges. They are administrator. They are a justice.
Yeah, they're all doing it.
Yeah, so they're not a real judge. I think the lady who actually came to that gentleman's trial to hand down her judgment was an actual judge. She actually didn't have her robe on and retired on that day. So,
Well, however they appear. First off, most of those folks are so mixed up they don't even know what their job is in the first place. So they might come in with a robe in, a robe off, or whatever. Until you get to someone who is very well educated, who knows what they're going to do. We've got some people sitting on the bench who are so poorly educated. That it goes beyond reason. I'll put it that way.
Yeah, I mean, when I went into the one court case that was dealing with my person, and I went in there and I spoke my language, and then I asked her a few questions, and mainly about the treaties, and she had no idea about any of the treaties that her queen and king had with my people.
That's it.
And I'm just like, really? She was ignorant. I was like, should I deposited or give you some document or some reading material that you can go review before we talk? Like it was so blatantly ignorant. She had no idea.
Well, sometimes it is a good thing to create what we would call a memorandum of law or a memorandum of points and authorities. Like I say, these people who have that job are very poorly educated on purpose. I mean, they put dupes and dummies in robes and set them on a bench and tell them, "Here's what we want you to do." And the first thing that they tell them is, "Whatever you do, don't study the law."
Yeah, you always got to bring points of law in front of them, or else they can't. But
They have,
what
no idea.
what's the other funny thing is they're bringing up case law from behind the bench against someone who's trying to self-represent.
Well, we deal with that too.
How would you deal with that?
Deny it.
Well, because there's this case in Canada called Meads versus Meads, and all these judges keep bringing it up against anybody. Then they're also labeling anybody who goes in to defend himself a free man on the land, which
Right.
therefore, which you get slam dunked in the court, and my one friend, he was doing a contract with this guy in a civil case. He the guy reneged on his contract and actually, cost him more money. And so the lawyer stood up and said, "Well, this guy's a free man on land," and that was it. The other guy won without even going into the case.
Well, look here now. If you go to the United States Federal Rules of Civil Procedure, or in Canada, you have something very similar. Anyway, in the United States, in the Federal Rules of Civil Procedure, there's addendums in there, which are the rules of admiralty. Now, in our Federal Rules of Civil Procedure, there's something, and by the way, everything is civil procedure, even though they call it criminal, it's still a civil procedure. But in any event, if you go to, I think it's Rule 9, I forgot what subparagraph it is. But anyway, it talks about specific negative averment. Now, because of the nature of the federal courts being an admiralty, you are assumed guilty unless you can demonstrate otherwise. And so summary judgment is had immediately upon filing of the complaint. So the remedy for that summary judgment is specific negative averment, which basically deals with the fiction. And so anything that is created by an attorney and put into a court is deemed to be a fiction, an assumption, unless it goes unrebutted. So you have to go and rebut the assumption to prevent it from turning into a presumption, because the courts can't give a judgment or ruling on a presumptive evidence. So the remedy for that is what's known as specific negative averment, whereas you deny that the thing that they're saying or doing exists. Now the burden of proof shifts from you back onto them, because now they have to prove that it exists, because the attorneys cannot introduce any fiction into the court unless you agree to it. And if you agree to it, they can put fictions in there all day long. So if they bring a fiction into the court, then you deny that it exists, and now the responsibility is upon them to prove that it exists. And if they can't prove that it exists, there's no subject matter. So when a judge or an attorney gets up and quotes some precedents, what would you do? I deny that Meads versus Meads exist. Now what do they have to do?
Prove that it does.
Yeah, if they can't prove that it does, then the assumption is burst asunder. But if you go in there and let them get away with that, then again the assumption turns into a presumption, and there you are, you're off to the races.
And a lot of people saying you don't even need paperwork as long as you can go into the court. You could do this verbally.
Yeah, it's good to do it verbally, but it should be a twofold process. It should be done on paper, and it should be done orally as well. Now, let me tell you one of the devices, that I've developed over the years, and that is the use of affidavit pleading. I never put anything into the court unless it's in affidavit form. Now, why would somebody think that I would do something like that? I'm using their same technique. Now, when I put a affidavit of specific negative averment into the court, number one, that overcomes their assumption of summary judgment because I'm rebutting line for line, point for point, all of their assumptions, and I'm denying them by specific negative averment. And because I'm doing it in affidavit form, now listen to this, because I'm doing it in affidavit form, that requires them to rebut my affidavit in affidavit form also. Now, an attorney cannot create an affidavit. An attorney does not have any firsthand knowledge of anything. And so an attorney cannot rebut an affidavit. And so when my affidavit has run for the requisite time, perhaps 21 days or 30 days, perhaps in some courts and whatnot, and when that affidavit has not been successfully rebutted, then I put in notice of default and request for summary judgment. I'm using their stuff just exactly the way they're using it, with a little bit of extra energy put into it. You see what I mean? So that's the reason. I've shown this technique since 2004 when I first started doing seminars as Solutions in Commerce, and it's worked very successfully for a lot of people if they press it. I mean, a lot of people just, take a template or something like that and put it together and put it in there and then expect the paperwork to do the work for them, but that's not always the case. Sometimes it is.
Yeah, I mean, I've seen a lot of guys, I help them with their paperwork. We go over it. It's pretty pristine. There's some good contractual liabilities in there. We've had the judges taking off cases. We had the Crown taking off a case because the paperwork. And he had to bring people in from other jurisdictions in order to deal with it. But sometimes the paperwork is there, and sometimes these people go in there and they don't know how to hold themselves verbally. They let these people walk all over them in the court. Well,
it's essential, for people. I mean, a lot of times, people's back is against the wall, and they do things without a good foundation and knowledge themselves. That's why it is essential, and that's why we put together this education program for people. It's essential to know how it works and what the proper things are to do before you get faced with a circumstance. I mean, I have so many phone calls from people, who are in an emergency situation, and it would be so much better if all the people would take the education and study it and be prepared, before they get faced with a circumstance. I mean, that just makes good common sense.
Oh, and the other thing is, what happened in the one court case is the judge entered a plea, and then I was telling these guys, because in my workshops I'm like, if ask them a question, if they're entering a fee, and if they don't answer your question, answer it for them on and for the record. The judge enters a plea and he goes, I thought only a defendant can enter a plea. He goes, no, the court can enter a plea for the defendant.
Correct.
And then he goes, well, he goes on and for the record, the judge is taking full suretyship and liability for the defendant by entering a plea on behalf of the defendant. He goes, and the judge goes, we don't have no contractual relationship.
You do.
He goes, well, it appears that you're entering a plea on behalf of the defendant. And then they went back and forth. And the judge goes, well, I'm not taking liability for that. And he goes, well, you entered a plea. And it's really funny. I have the audio up on YouTube. and then he goes, well, he goes, you're arguing liability. He goes, you argue suretyship. That's it. And then he kind of was, it's such a funny back and forth between these two, because he starts going into calling it mumbo jumbo. He goes, your mumbo jumbo was going to work in the court today or something like that. And I know mumbo jumbo is magic.
Well, that's why, if it says, when it says something like, use a term like mumbo jumbo, you say, will you please define what mumbo jumbo is? Because I have a law dictionary and I can't find that.
Well, yeah, well, they just keep, when you ask questions, they don't answer. They just keep on trucking on.
All right, now here's important. Here's something that's really important for people to do. Number one, you're the court. Not the guy sitting up front, not the clerk. You're the court. Now, and so everybody there is working for you. And so if you ask one of your employees a question and they don't answer it, what should you do?
Oh, we give them the answer.
Answer it for them. For and on the record, Judge so-and-so refused to answer this question. Therefore, the answer is, for the record, whatever.
I did that. The judge goes, I didn't agree to that.
Oh, yes, you did, but you're silent, you fool. You idiot. Shouldn't say fool. That's a bad word to use. But no, they did agree to it when they didn't answer.
She agreed the second time when she denied it, because those who deny admit.
Yeah.
Isn't that Maximo law?
Well, yeah. If she denied it, then she authenticated that it does exist. Now, she only denied it from her position. Did she change the record? No.
No.
When you went on the record, I mean, she can say denied or object or whatever you want to say, but now it's a part of the record. The only way they can remove that from the record is to hold a trial.
Yeah, they want to hold a trial. That's what they've been trying to do with me.
They want to hold a trial to remove that from the record. I mean, what I'm saying is, in order to get something off the record, they have to hold a trial. And that trial has to be a jury trial because now it's a part of the record. That's why it's so important to go on the record when you say things.
Oh, and that's why you'd want to request a jury trial, wouldn't you?
No, they would have, if they want to remove it from the record. If a judge removes anything from the record, unless a jury should take that responsibility upon themselves, then that judge is guilty of evidence tampering, which is a federal crime.
And do you know of any way to get any of the transcripts without paying out the yin yang for that?
Transcripts of a trial?
Yeah.
Well, make your own record.
You mean bring in your own recorder or audio?
Yeah, in a lot of cases, if it's serious enough, people will bring their own recorder, or court reporter, and get an official transcript. Or you can simply, after the hearing or whatever is over with, you can memorialize the conversation in affidavit form.
Okay. Yeah, a lot of guys are recording it now in the court.
Yeah, good.
That's where I got the audio from.
Great.
The audio isn't great, but you could still hear what's going on, and you can hear a lot of the judges bantering back and forth. And what's going on is now they're not even really trying to hear you anymore. They're just grabbing you and throwing you in jail if you start.
That's when you know you're winning.
Yeah. The one guy got thrown in jail for the day because he wouldn't stand up for the judge.
Did they bring the Bible in front of him?
No. The bailiff was just like, you need to stand. And he went.
Historically, the only reason we stand is because the bailiff would bring in the King James version of the Bible in front of the judge. So nobody was standing for the judge; they were standing for the King James version.
Oh, okay. So that's where standing comes from.
Correct.
Huh.
That's why I ask you. If if the bailiff told that guy you need to stand up, the first question he should ask the bailiff is, well, where's the King James Bible at? I only stand for King James. You understand that King James version of the Bible, when it was created by King James, of all people, it was authorized for use in the churches and the courts. Now, the reason why everybody in the courtroom stood up was not because the judge came in, it was because the King James version came in, and they stood up on the basis that the King James version gave them standing in that court.
And you know what? That's the first time I heard that. I never heard that.
Well, it's historical. Now, it used to be that when witnesses were called to swear in, do you promise to tell the whole truth and all that kind of stuff, that they put their hand on the King James version. because again, it's not the Geneva Bible. It's not the Dead Sea Scrolls. It's the King James Version that was authorized by King James for use as an authority in the courts and in the churches. So based on that authority, then people were willing to swear that they would tell the truth. And then they were held to it on that basis. And so the key to the court system, again, is the King James Version of the Holy Bible. And if the bailiff don't come into court carrying the King James Version, then there's no standing in that court for anyone. But then again, we're getting back into some of the common law concepts, and now we're operating in Admiralty.
And that sort of thing doesn't happen, and I've never seen that happen in Admiralty, them carrying a Bible.
Well, if you want to, bring your own King James, but if the bailiff, told the guy, said, hey, stand up for the judge, all he had to do is say, my leg hurts, I can't stand up.
Yeah.
He shouldn't get into an argument with it. He should do a demur. Just say, oh, I'm sorry, I can't stand up, my leg hurts.
Yeah, well, this guy said, he said something to them, and then the judge ordered the bailiff to take him away.
Well, there you go. I mean, he got into an argument. He should have got into a demurrer to say, I'm sorry, I can't stand up, my leg hurts.
Yeah. Let's get back into the you brought up comptroller to collect, and that you said that we're using, and I was sort of wanting to go back on that. When you say we, what would we be using in order to collect on that side to go to the comptroller?
I don't know what it's called where you're at. Here in the United States, each county has what's called a county comptroller, and they're the ones that all money passes through in regards to collecting funds at the federal window through the U.S. Treasury. And so I don't know what it's called in Canada where you're at, but any kind of instrument that's taken to the federal window for collection. You understand that any debt of a U.S. citizen is collectible through the U.S. Treasury, and in our case, it's the county comptroller of currency that does that. And so what's the applicable thing, where you're at in Canada? I don't know the answer to that. You'll just have to investigate.
So when you're saying any debt, you saying you could take someone's bill and go get a check for it?
Technically, if you want to go back, for instance, and look at acceptance for value, and the use of that coupon like you were talking about, turning it into a bill of exchange, you understand under negotiable instrument law, there's only two kinds of instruments. It's either notes or drafts. A note certainly is a two-party instrument, but a draft is a three-party instrument, which changes the nature of it. A note, for instance, is a deferral item, whereas a bill of exchange or a draft is a set-off item. And so when we do acceptance for value and we go ahead and create a bill of exchange, which people are calling a money order, or call it, makes no difference what you call it, it's a draft. Anyway, technically, let's say, for instance, a court case. On a court case, if you do an acceptance and return for settlement, then the court should technically take that acceptance to the county comptroller for the settlement of the account. But they're not doing it. So sometimes you have to force their hand on it. If need be, you could actually take an acceptance for value on a court case, and some have, directly to the county comptroller, so they'll take it to the federal window and get the funds transferred, again, on the basis of the Chapter 11 bankruptcy we're running. It's all in the adjustment of the accounts. Adjustment. Write that word down 1,000 times. Adjustment, yeah. Adjustment. That's what we're doing with accounts.
That's all as part of my documents. I always say adjust the account to adjust the account or ledger the account. Is it ledger or adjust it? What?
Either way, adjust is fine. Anyway, what you're trying to get over to them is, to use what I've given you to adjust this account, and just tell them, hey, I'm doing this out of my goodness of my heart. I don't have to do it anyway.
Yeah.
Because you folks are in violation of public policy by what you're just doing. So I'm bending over backwards here to help you out of the problem that you're causing. So here it is. Here's all the information you need to adjust this account. Go get it adjusted. If you don't, then you fall under breach of fiduciary.
Oh, that brings up another little thing when we're talking about courts here. is a lot of these guys are appointing lawyers as a fiduciary to go ahead and take care of a lot of these cases, and they're totally ignoring the appointment.
Well, then they need to be sued for breach of fiduciary.
So they can need a civil case brought against them.
Yeah.
Because I guess a lawyer, that's part of their job. If someone appoints them, even a judge, can you appoint a judge as well?
Yeah, we've done that. We've done it in Canada. I mean,
Oh, really?
did I tell this story before?
No,
Yeah.
no.
A lady in BC called me up. She's right in the middle of a criminal case, and her ex-husband was in fact an attorney. And he was, oh Jimmy, he was stealing everything she had, and charging her criminally. So she got into a criminal thing in a court up there, and she called me up. She was kind of deep into it, and she was asking me, was there anything could be done? I said, well, yeah. So I gave her the information about her being the settler of the, straw woman account. And I said, the next time you go to court, I said, do two things. Have them ready. I said, number one, take a copy of the complaint, do all the acceptance language on there. And I said, number two, create an invoice. She said, what's the invoice for? I said, for all the time you spent in jail and for all the property they stole from you. So she created a certified invoice, and it come to something like $3 million. They had taken a lot of property and put her in jail. So anyway, I said, when you go to court this next time, I said, you announce to the judge that you're the settler on the, Jane Doe, whatever her name was. I won't give her name. Anyway,
Yeah,
I said,
Jane Doe's
tell
good.
the judge. Yeah, I said, just tell the judge that you're the settler on the Jane Doe trust and that you're also the beneficiary. I said, at that point, I said, hand over the acceptance for value, which is for return and settlement. And I said, also at the same time, hand over that invoice and then demand payment on the invoice. And she did. She went right back in and did it. And that's the last time they ever had a hearing. The case all of a sudden went dead. So she called me up and said, well, it's all gone dead now. She said, but what about that invoice? I said, well, go ahead, just like ever. And I said, send them a 30, a 60, and a 90-day notice. And I said, then once you've done that, and I said, that invoice turns into a security. And she knew what to do with the security. And so last I heard, she was still trying to chase down her money. I don't know if she ever got it or not out of them, but I'm just telling you, it sure brought an end to that criminal case.
So she didn't appoint nobody in that one. She just was invoicing
Yeah, she appointed the judge as the trustee fiduciary.
like verbally, or did she do that in writing?
So as the settler, yeah, verbally, right there on the spot. So she came in, she announced, I'm the settler on the Jane Doe Trust, and I'm also the beneficiary, and I'm appointing you, Judge, as the fiduciary trustee on the trust. She passed over the acceptance for value. She passed over the invoice and asked them how quick they could get that invoice paid, and that's the last you heard of that court case.
So she did that. So she handed over the originals in court.
Yeah, original signature documents always.
And did she have that document that you had attached to it, or did she just hand over the original document, or does she have some sort of court document in order for them to recognize it?
Let me go again.
Just a bit, just because I'm sure a lot of people are listening and are going to be. Okay.
Okay, let me go over it again. Yeah, she took a copy of the complaint and she wrote the acceptance for value language on there, complete with deposit to, I don't know, we may have deposited to the Crown, Treasury, or whoever it is where you're at. Anyway, so she, in charge back, against Jane Doe, and then she gave her SIN number on top of that. All right. So along with that original signature acceptance, she created a certified invoice where she went and ledgered. She was in jail, all the property they had stole from her. She got a notary to notarize her signature on that invoice, turning it into a certified invoice. And then when she went to court, she took those two documents, She came in as the settler and beneficiary, nominated the judge as the trustee, passed over the original signature acceptance, the certified invoice, and then just said, how soon can you get that invoice paid? Now, they didn't pay it. The trustee did not pay it. Now, what does that mean? The judge is in breach of fiduciary. And could that judge have been sued on that invoice? The answer is absolutely yes.
So she could have brought up a civil case against that judge then.
She could have, for breach of fiduciary. You understand that the judges and all of the public officials, by definition, are fiduciaries to the public. And they have a fiduciary responsibility, and they can't get away from it. They're getting a paycheck. They're being paid to do the job they're being paid from where? From the public. They're getting a paycheck. They have a fiduciary responsibility. So when you go and nominate and appoint them a fiduciary and they don't fulfill the demands placed on them by the beneficiary, then they're in breach of fiduciary. And yes, indeed, they can be sued, and they could actually be prosecuted criminally because they're doing it with knowledge. It's not a mistake that they're not performing. So you can sue them civilly for the damages, or you could legally bring a criminal charge for breach of fiduciary with knowledge.
Yeah, I think we'd probably have to find out how that interprets out here in Canada.
Well, here in the United States, we'd probably go to Title 42, United States Code, for that. There's other methodologies and stuff we've used to bolster that up and make it a little bit stronger and so forth. Don't want to go into a whole lot of technical stuff, but in any event, those are the principles that we operate with. All we've done is just go back and say, well, if it's good enough for the goose, it's good enough for the gander. So this is how you're doing it. So this is the way we'll do it.
Yeah, yeah.
And they don't like it very, very much when it gets thrown back in their face. Well, that's just too bad. Cry me a river of tears, but you're the guys that set this crap up. If you don't like your own crap, then stop trying to force it down our throat.
Yeah, they're more or less say, hey, we're doing it, but you can't do it, kind of thing, right?
Yeah. So over the years, we've simply studied to see how they're doing things and say, well, okay, if that's how they're doing it, that's the way we'll do it too. And so we throw it right back at them the same way they throw it at us. And then they cry and whine and say, you can't do this, you can't do that. Why not? You're doing it.
Yeah.
If it's good enough for you to do, why is it wrong for us to do it? I mean, you're the guys that set the system up. Don't cry when we use the system.
Yeah, there's another guy. I think he put like about 200 or 300 pages worth of case law in order to establish.
Oh, geez, that's a waste of time.
In order to establish, that this is why he has the right to travel, and this is why he has the right to do this and that.
That's a waste of time. All you have to do is put together that proof of life demonstrating that you're a living sentient being, and get that into the record, and then you're off to the races. At that point, then the fictions can't deal with you. And again, if you go to the extent of putting that fiction and all those accounts and everything on a UCC financing statement, now you're in the first claim position anyway.
Do you have a example of that somewhere, or
of what?
That like what that might look like to put it on, or do you just get a UCC1 financing statement, put those driver's license and SIN number and different numbers on that UCC, and then file it in there, or?
Well, you're talking again. I think last time we talked about the difference between a national UCC1
yeah, we did talk about that.
State form.
Yeah.
I of course prefer the state form because it's recorded and not filed.
Right.
If you use a national type form, then you're going to have to go to other measures to get into the same position that you would be in if you could get it recorded. And so, maybe people can go back and review our conversation from last time.
Yeah. No, that's totally what I wanted to get at. Maybe we'll get into the UCC real quickly here. Just to bring it up, after we had our conversation, I went down to a county recorder office, and we brought in some UCCs, and they didn't really want to file it because the property that we were filing the property that we were filing didn't have anything to do with that county.
Well,
she's like, we'll record it, but it ain't really gonna have any effect on that person's property.
Okay, one of the things we do to get around some of that is we use a self-authenticating security agreement. And then within that security agreement itself, which is a binding contract, which is authenticated by the fact that they don't come back and rebut it. So we get into a self-authenticating security agreement, and then we take the security agreement itself, which is property by definition, and then we record that property on the UCC financing statement. So at that point, then the property in question, whether it be a driver's license or a deed to a property or birth, whatever. Anyway, at that point, then we get into that same position. And then I don't see where your county officials will have any problem recording a UCC1 financing statement that has a security agreement attached.
So you would actually bring the security agreement in there with your UCC1 and have it attached to it as you record it.
Yeah, it would be. It would be on the financing statement as collateral.
The security is the collateral.
The security agreement itself is collateral.
And the security agreement would have the property you're leaning in the agreement.
Yeah, you can either attach it to the financing statement, which if it's several pages, it's going to cost you a little bit, or you could simply refer to security. Put a tracking number on your security agreement. 1, 2, 3, 4, 5, or whatever.
Yeah, and then put that on the UCC.
Yeah, and then just refer on your financing statement to security agreement, number 1, 2, 3, 4, 5, in the possession of so and so, that can be in possession of the secured party, because the address of the secured party is going to be right there on the financing statement.
Yeah, and then that way you wouldn't need to put the actual property that you're going after, because it'd be in the security agreement.
Yeah. See, it goes back to the concept that paper is property. Contracts are property. Security agreements are property. So you list them as collateral. If anybody wants to come to look at it, they can certainly, you certainly would provide them that opportunity. But in the event that you had to go into court, now you bring your financing statement along with the security agreement and say, look, this thing has been recorded, for 2 years now. It's a part of the public record. Anybody that does business with my debtor, they had the opportunity to go and look at it, but they never did. So, tough luck. And so now you bring your security agreement along with your recording of the UCC1 financing statement into court as the superior claim. You have to understand that in these Admiralty courts, the real question is who has the claim on the described property that's a part of this civil suit or criminal suit. Who has the claim on that property? And so when you show up in court with a superior claim, then that demonstrates that you're the party that has the right to the property, whether it's your body or whether it's to a house, a car, to a contract, to a driver's license, or whatever. You're the one with the superior claim. That's how Admiralty works.
It's all about claims.
It's all about claim.
It's a claims court.
Of course it is. It's a small claim court. You turned it into a small claim court. That's what you do.
Because what they had done is the one guy, the document we did for him, it was funny because he put the debtor and creditor on the bottom. He altered the document and he put creditor, debtor,
and
then he signed. But the problem was he was putting a lien on the Queen Elizabeth or Queen.
Oh, that's not really smart. And
so he like signed Her Majesty the Queen or whatever. And then the lady was looking at me like, I was like, I don't know, man. I was a trustee. He told me to come down and do this. And she's like, well, we can't file that. We know for sure that's not the Queen's signature.
Yeah. See, in order to record or in order to file either a national form or a state style form of a UCC1, you have to have the permission of the debtor to do it. In other words, you have to have exhausted administrative due process. Now, I will say that acceptance for value does, in fact, complete administrative due process. And so you could legitimately file a UCC1 financing statement on anything that you had accepted. But in order to put the Queen's name or put her signature upon a document, you would have to have her permission to do so. And first off, it's a foolish thing to do. There's no reason to do that because, again, John Doe is the same thing as the Queen of England, is the same thing as the United States of America. United States is the same thing as the United Nations, is the same thing as the Federal Reserve Bank, is the same thing as the Bank of England. They're all the same thing. So if you go file a recording, or if you go record or file something against the debtor, John Doe, you have recorded against all of the fictions because they're all the same thing. So there's no reason to get the Queen involved in that stuff. By implication, she's involved in it when John Doe's involved in it. So, I mean, that's, you know, why stir things up when you can do it this other way?
Yeah, yeah. I thought it was just funny. I mean, but yeah, she kind of looked at me, but she's like saying, "Well, if you want me to file, I'll file it, but it ain't gonna have no real effect." She goes, "If you what you should be filing is up in Canada. You shouldn't file it down here."
Well,
Like she got the manager out, and this other guy came out and was just sort of like, kind of looking sideways.
yeah, the real question is whether or not you have the permission of the debtor to sign their name. Now, if you could demonstrate that you did have the permission of the debtor to sign their name, for instance, here in the United States, or what we've done in the past, again, in regards to the debtor, is our straw man debtor. We get their permission by the use of that self-authenticating security agreement. And so based on that security agreement, then we're authorized to sign the name of the debtor. It's all in the fiction, folks. It's all in they created the game. If they can't complain if we learn the rules and if we play by the rules. Matter of fact, if we do play by the rules, we're the only party in existence that does. They certainly do not.
Yeah, in a lot of the documents I do have that failure to respond, or upon a default, you're granting and conveying a specific power of attorney to execute any and all documents and pertaining to this actual case. Meaning,
of course,
I can go in court, get a summary default judgment. I don't even need to send it to the party. I can just say, yeah, I agree. I got power of attorney over that. So both parties agree right now.
I once got a communication. I forgot who it was from. It's either a bank or it was from a IRS or somebody. I can't remember who it was now. And they didn't sign the documents. I wrote back to them and said, hey, you sent me a document here with no signature on it. I said, unless you tell me otherwise, I'm going to sign the President of the United States' name on that. But anyway, if they send unsigned documents, just write back to them and say, well, you didn't sign your document unless you notify me otherwise. I'm going to sign your name on it, and that's their agreement. If they don't come back and say no, don't do that, or if they want to supply you with an original signature on the document, that'd be fine. But if they won't sign their documents, if they send stuff to you, write back and say, hey, unless you tell me otherwise, I'm going to sign your name to this. And that's their agreement.
We would put the CFO's name then.
Sure, you can do that. I used to know a guy. His favorite trick is he would contact, for instance, a bank or something like that. And he would say, unless you tell me otherwise, this is your tacit agreement that I can use your letterhead. And then when he would do things, for instance, if he's going to do a reconveyance on a property or something like that, he would simply use the bank's letterhead to do the reconveyance.
And so how would he sign their name, though? Like, say it was...
By their same agreement.
So it was John Doe. He write, John Doe 1 signing as power of attorney for John Doe 2?
If he's going to do a reconveyance on property or something like that, he get the bank's permission, number one, to use their letterhead, which looked very good. Then he would also get the permission of the CEO or CFO or whoever, to put their signature on it. So now all of a sudden, down at the recorder's office, a reconveyance shows up, from the bank with the bank's letterhead, the bank signature on it. What do you think they're going to do down there at the recorder's office?
They're going to reconvey
Of course they are.
it.
Hey, it's the game they created. They
Well,
can't cry about it.
but I guess what I'm trying to ask is that you don't need to put sign as power of attorney. You could just put their signature and that's it. Because you asked them, you said,
Yeah,
I'm gonna sign your name, and if you don't say nothing, then you're giving me an agreement that I'm gonna put
it's a
your signature.
contract. See,
Yeah,
this is the way we used to always, for instance, in court or to a law official, they would say, say what's your name, or the judge might say what's your name. Well, what's the response? The response is, well, what's your name? Because that judge knows if he can get your name, now he has contract with you and he can use that name. So if we come right back, we don't give him a name. We just say, well, what's your name? The judges will never give you their name. They know better to do that because they know that if they give you their name, that you can use it however you want to.
yeah. Is that good? Maybe go in there with a name tag.
That's what I always go. If I go to court, I always put a name tag. I never say my name in a court.
They'll say, well, please state your name for the record.
I say it's right here on my name tag. Can you see it from where you're at? Do I need to get closer?
And you say, well, we need you to state it for the record.
Well, then you ask them for their name.
Well, oh yeah, could you please state your name for the record first?
Yeah. If you won't state your name, why would you expect that I'd state my name?
Yeah, see, I like these games. That's a kind of.
I once went into it's a small court. It's kind of like a magistrate or a traffic court, and that thing got started, and I had my name tag on, so I went through that routine. But then I told the judge, I said, you know what? I said, I don't know who everybody here is. I said, what's your name? He pointed to his name tag, so I wrote it down. So I said, well, who's that sitting next to you there? That was the clerk. And he actually gave me her first name, didn't give me her full name. And then the bailiff, I pointed to him and said, what's his name? And I knew his name because I was holding a $3 million lien against him. I knew what his name was, but I wanted him to say it. The judge gave me his full name. And then I turned to the attorney and I said, what's your name? And he gave me his name. Can you believe that? He gave me his name. I said, what's your bar number? And he wouldn't give me his bar number. All he said was, well, he said, if I decide to prosecute you, he said, I'll give you my bar number. Well, they dismissed that case.
Yeah.
They dismissed that case.
Yeah.
I learned that name game a long time ago with my kids. One time we were going across country, going back to see Grandma, and I had a bunch of kids, and in the back of the pickup truck, under a camper shell. They were back there just rocking and rolling, raising the dickens back there. And I had one of my teenage sons with me to be a co-driver, and I said, look, I'm going to pull over here. I said, go back there and settle them kids down. And so I stopped, and he jumped back there. Within 30 seconds, everything was quiet back there. And I wondered, what did he do? Did he pop a few of them, or what did he do? And finally, I asked him, I said, how'd you get them kids to settle down? He said, I just took a pencil, a piece of paper, and he said, I'm taking names. He said, they all shut up. So I learned that a long time ago. That name game is really important, really important thing. I don't know what it is, but it's really an interesting situation.
Yeah, it was really interesting for me too, because when I went into court, I said I'm here as John Doe, and the lady kept going, I don't understand. What do you mean? Are you John Doe or are you not? I said, well, what don't you understand? Did I not say I'm here as John Doe? and because I know the word "as" defined in the dictionary is to be in the capacity of or presence of, it does actually mean that you are.
Sure.
And I'm sure they knew that. That's why else would they keep haranguing you about, what do you mean as? Are you or aren't you?
If you want to get into contract with them, and you might want to get into contract with them, you might ask them, well, if I give you my name, what are you going to do with it, or what are the terms of the contract that I'm entering into? And you may or may not want to give your name based on the terms of the contract.
Yeah, they won't reveal it. I'm pretty sure from what I hear in Canada, they're pretty rogue up here in Canada. They're really they're really out of control. A lot of these judges and bailiffs. Like these bailiffs grabbed a bunch of guys and started slamming them around on the hallway in the court.
Well, there you go. Anytime they resort to physical violence, it means they're losing. Now you might ask, if they ask for your name, you might say, "Well, I'll tell you what, I'll give you permission to use my name, for it on the record for 30 minutes."
With no price tag to that.
Well, you could put a price tag on what you're saying, but establish the contract that they're going to go by. If you give them unlimited contract, they do anything they want to. So they say, we're going to hold you in contempt if you don't give your name. You say, well, I'll give you my name on the basis of the following contract, that you can use my name. You cannot trade upon my name, but you can use it for the next 30 minutes. And then if I like the way you use it, I'll let you use it for a little bit longer. But it's only going to be in use. See what I mean?
Yeah.
Contract with them. If you don't put the terms of the contract, if you just give them their name, it's like signing your name on a document unrestricted. You always put by, or authorized representative or beneficiary or some kind of restriction on your UCC 1-308 kind of thing. You always put some kind of restriction anytime you sign the document. If you say your name out loud without giving any kind of restrictions on it, they can do anything they want to with it.
Yeah, so you say, "Oh yeah, I'll give you the name on condition that you provide me $10,000 right now after doing so."
Yeah. Well, I accept your offer to contract, and I return it to you for the value of $10,000. So go ahead and cut a check for $10,000, and you can go ahead and use that name for the next 30 minutes or whatever. See what I mean? You have to establish the terms of the contract. They're trying to contract with you.
Oh yeah.
I was once at a hearing, and I was helping a fellow on a criminal matter, and it didn't go the way that the court liked it to go, and so I was accosted out in the hallway after the hearing by an attorney, and the attorney jumped in my face and was yelling and screaming at me and making all kinds of accusations. And I looked him right straight in the eye, and I said, "I do not contract with you. Get out of my face." He shut up immediately and walked away. I said, "I do not contract with you. Get out of my face." He just turned around and walked away. So again, it's about verbal contracts and all kinds of tricky things. They think they're the only ones that know anything about.
Yeah, there's a few. Do you have any stories like that? That's a interesting story. Do you have any other anything that comes to mind of like when I told you about the guy? He says, "Well, you're going to be taking liability and suretyship for the defendant." And the judge goes, "Well, we don't have no contractual contract with each other to do that."
Well, then doing that, first thing I would ask him was, "Well, Judge, did you get a paycheck this last time? Are you being paid for sitting there?"
You say, "Of course."
Well, then you have a fiduciary responsibility, because I am one of the public, and you have a fiduciary responsibility to the public.
And this one judge, after he was bantering back and forth, he said something like, he looked out to the crowd. He didn't look at the defendant. He goes, "Everybody here is on a social contract, whether you agree to it or not."
Let's call it an adhesion contract, and it's unconscionable.
And then if I was the guy who I was helping, if I was him, I would have said, "Well, what makes you believe, is this a dictatorship where I can't say what I agree to or not? Is that what you're trying to tell me?"
Well, you could say something like that, but hey, if the guy wants to contract, all you got to do is put forth the terms of the contracts. All you have to do is indenture the trust that you're getting involved in there, and appoint him the fiduciary, and then tell him, carry out the demands of the contract, carry out the demands of the indenture here, and I'll give you 10 days to get it done. And if you don't, I'm going to sue your pants off for breach of fiduciary, bring a criminal charge because you do it with knowledge. I'm going to prefer a criminal charge to the Attorney General.
Yeah, yeah.
What would happen if all of a sudden 10,000 people did that?
Yeah, that would do a change. The other thing is, here's something that came up recently in Quebec. They actually took down the criminal code, or the criminal code is becoming they can't use it no more because they're saying that the Queen has become a litigant, or not angry litigant, but a what do you call that?
Belligerent?
Not belligerent. There's another word they have, and I can't think of it right now. I don't know why, but Vexatious litigant.
Oh, good.
And because this one gentleman was, I guess he was doing what you're saying. He was bringing criminal charges against people, and I guess he had about 10 or 12 of them going on at the same time.
Hmm.
And they said, well, we can't allow you pursuing these no more because you're a vexatious litigant. And then so I guess he brought up some other case and said, well, the Queen's a vexatious litigant. I'm only bringing 10 or 12, and she has about 20,000 going on at the same time. So that brought down the criminal code. They weren't able to use it no more. Or now it's for some. I think it just happened recently. So I think they're going to start using that the Queen's a vexatious litigant,
Good.
and therefore you throwing out any charges that she brings.
Good.
For those who may not know, and plus there's no civil code in Canada other than in Quebec.
Quebec's kind of a different place. I think they still have a lot of French law and stuff intertwined.
Yeah, Napoleon law.
Yeah, the Napoleonic law. The Napoleonic law is different. We had that same situation down here in the state of Louisiana, and they were operating under Napoleonic law to a large extent. But it took a long time for the Uniform Commercial Code to be statutized in Louisiana, but it's been done now. But yeah, we've had that same problem down here. We had quite a few French background people down in New Orleans and places like that.
Yeah, and what I was thinking is civil Quebec is Upper Canada,
Uh-huh.
and I think there's an Upper and Lower Canada from a long time ago, and the Quebec Civil Code, which would be the QCC, kind of almost sounds like a UCC to me.
Good. I don't know.
Because from what I've researched in Canada, there is no law governing the laws of contract like a UCC or in the articles.
It depends on how the contract is to be executed. If it's to be executed in fiat currency, it's not a contract. If the contract is to be executed in gold or silver, it can be a private contract. Or commodities. Wheat, lumber, all those kind of things. Those would be appropriate contracts because they can be executed because the contract is executed in substance.
Oh, so like a house or a car or something.
It could be, but you have to understand that when you're dealing in real estate and in vehicles and so forth, you're only dealing with the title to them. That's where the rub comes in.
Oh yeah, because you're not actually dealing with the physical; you're actually just dealing with the paper.
That's all you're dealing with.
And that's fiction.
Yeah, when you go for a real estate deal, the only thing that happens is a transfer of title. They don't transfer the house. The house has to go into escrow. A lot. Well, we're going to get a long discussion here to explain all that to the people who are listening. That might be another hour, and we're kind of coming up on a little bit of time here, so we have to cut it off before it gets too long. But
we can go into that into another. And if we do another one, we could follow up with that.
Sure.
But maybe a little bit of. We went into the UCC a little bit there. Registering the birth certificate, because you'd put your birth certificate on there as well, right?
Yeah, I would.
And the SIN number and driver's license and
anything, yeah.
What people? Someone asked me, why do we want to lien our straw man? Why do we want to put a $3 billion
to get into the first lien position? Again, who has the claim on the assets of that are registered to the straw man? Who has the claim on that? Do you want somebody else to have the claim, or would you prefer to have the claim?
And so if someone will try to go for a credit card or a mortgage, that lien on the name won't show up.
It would if you bring it into court.
Oh, okay. So
put it on the record.
So a credit reporting agency wouldn't have access to that.
They should. You have to understand this one concept. People should. Memorize this and think about it. And that is, whoever does business with my debtor becomes my debtor. So if someone is doing business with John Doe in all capital letters, then if I have a legitimate claim on John Doe in all capital letters, whoever does business with John Doe and all the capital letters now becomes my debtor. And so before doing any kind of a business deal or whatever, certainly people should go and do a UCC1 search to see who has the claim on that debtor. And if they don't do it, then they fall right, they could in fact fall right into a trap. For instance, let's say, for instance, that I have a security agreement, a self-authenticating security agreement with my straw man. I have it on a UCC1 financing statement, either filed or recorded. And then someone decides that they want to do business with my straw man. And let's say they're able to extract, for instance, like through a court, if they take a complaint and take it through the comptroller and get funds for it, the question is, whose money is that? It's my money. You go look at the security agreement. I have the first claim, and my security agreement basically states that the straw man owes me, let's say, $10 billion. That's why I've said in the past, in order for anybody to actually profit by anything they get from my straw man, they're going to have to get $10 billion in $1, or they're not going to get anything. Because the first $10 billion are mine. That's how the UCC works. So we put these things in place. Are you capable of enforcing them? That's the only question. That's why we have education for people.
And I guess the recording the state form. Now the national form and state form. From what I could tell, you can only seem to get the national form online. You can't get a state form online.
You used to be state form. We generally had to go and get a physical document, but you can make your own. The first UCC one I filed, I just made my own. I think you have a copy of it. If you don't have a copy of it, you send me an email. I'll send you a copy of it.
Okay, yeah, I'll do that.
It's all over the place. I can't imagine you don't have a copy. But
is that green one?
Yeah,
I think I've seen that.
Yeah, that's a state form. That's a state form that I created.
So you would just
based on their state form.
So you would just change the state name in order to follow, like, because I'm in Washington State down here in Vancouver area.
Sure.
And so we would just take your form and then just make something similar, but just put the Washington State
instead of Kentucky.
And then go down to the recorder and record your birth certificate with a $3 billion lien on it. Now, does there have to be a security agreement?
I would put all that in a self-authenticating security agreement.
Yeah. So what about? I mean, another issue with people is the police. Recently, there's been quite a few videos of them beating down a lot of the First Nation people. As they put it in the news. I know my people aren't First Nations. We're the Haudenosaunee, or the whatever name that we're using for whatever nation, whether we're Mohawk in our language or Cayuga or whatever.
Yeah.
These guys, I think they need to be taught a lesson, and I think their bonds need to be taken or made a claim on. And a lot of these guys.
Let me tell you what I did years ago that might be of interest to you. And then we have to cut this off, okay?
Okay.
Years ago, when I was first learning all this stuff, I came upon information basically from Hartford Van Dyke and other parties who were using commercial liens. And so I studied into that and found out, I'd studied it and learned it and all that kind of thing. And so an opportunity came up for me to first try it out. So I did. And so on a particular occasion, I got pulled over by a law enforcement officer who happened to be a marshal for one of the small towns around there. So anyway, he pulled me over, and without any particular reason. And so I went through all that rigmarole. And then what I did was I went and put a commercial lien on this officer in his private capacity. And you know what happened after that was they took him out of the patrol car, put him on the desk, and as far as I know, he's still there, and that was about 13 years ago. And the reason why it was because that lien was not paid. They could not bond him. they could not get an insurance policy on him to allow him to be out in a patrol car. Now all these people that are beating up, citizens or native, first, whatever you call yourself, Native Americans, whatever. If if they're profiling or whatever, that was what I did way back when, and it seemed to work real good.
Yeah, these guys won't give you. They have a number, and there's no, and the station won't give you their name, but their name is on.
That's not a problem. John Doe doing business as number 12345.
Yeah, they have a last name and an initial, and that's about all you'll get. So I'm wondering, how did you find out this guy's personal info in order to even get a lien on any of his personal property?
In his case, I asked him his name and he gave it to me.
Oh. And so then you're able to research and find out everything about who he was, or
I didn't need to know everything about him. In the United States, I don't know if it's the same where you're at, but each officer is required to carry a business card. He gave me his business card with his name and information on it. And so anytime we're stopped here in the United States, it may not be the same where you're at, but we always ask them, I need a copy of your business card, and they're required by law to give it to you. They won't usually give it to you until the transaction is over with, but that's fine. And so we always ask them for their business card, and they'll produce their business card.
a lot of them tell me they don't have it, or they'll when I ask them for ID, they start pointing at their uniform and going, that car and this uniform. They said, we don't need identification.
Don't get into a confrontation with these people, because they will, draw guns or clubs or whatever and beat you with it. Why go to a lot of trouble? Agree with your adversary while you're in the way with him. You agree with them. Sign their documents or all that crap. However you want to sign the stuff, and then go do your business. When you're not in danger of getting beat up or shot.
Yeah, that's what that's my way all the time. I tell these guys to do that, because once he started, when I questioned the guy when he pulled me over, right away he starts he called backup, so 10 cop cars are behind me.
Great.
So then I just
now you got 10 witnesses.
It's okay, here we go, and I start, because I had a contract that I wrote up on my car. It says anybody who makes a commercial presentment to me or puts a commercial presentment on the car pays me $5,000, and towing it's $15,000, and don't do it if you don't agree.
Good.
So, just like any parking sign, it says, don't park here if you don't agree to terms and stipulations. So I said, don't do any of this stuff unless you agree with the terms and stipulations herein, and it's all notarized, and it's stuck to the car. And
sound like you're well on your way to getting things taken care of there.
Yeah, I invoiced the guy who towed the car. So, the guy, the owners of the tow truck company's face dropped when he saw me hand him these documents with the agreement that he's agreeing to, offer up all his movable assets and everything in exchange for the $15,000 that he agreed to pay me. And I said, each month you don't pay me, it's going to be $100,000. And I said, it's about $1.2 million for every year you don't pay me.
Yeah.
I said, that's the penalty if you're not paying me.
There you go.
But yeah, I mean,
now all you have to do is enforce that contract.
Yeah, that's the problem, and that's
all you got to do is send that contract to their bonding company, and they'll shut them down. See, that's what happened when I put that commercial lien against that officer. It got back to the bonding company, and they would no longer issue a bond on that officer. And if they couldn't bond him, they couldn't put him in a police car where he would go out and create any further liabilities, because then it'd be on them. He was an uninsured motorist if he went out.
And the thing is, a lot of these guys, don't they have to give you their policy number and the underwriters of their policy?
Well, if you go and record in the county recorder, there's a vehicle within the recorder's office that the bonding company will be notified.
Oh yeah, and so even in Canada, UCC they'd be notified in Canada as well.
Could be. I'm not sure how everything works in Canada. I'm just telling you how it happened with me, and then you can make something work. Yeah,
they have the PPSA, which is for movable property, and this thing called the Taranet, TARANET.ca. It's something for property. But it's frustrating up here because they don't really have any UCC sort of implementations except for the PPSA.
Well, uh, there's ways to get around all that. I mean, if you have to, you can always record in the Washington D.C. For international UCC one filings.
Oh, there's an international UCC one filing.
Yeah, Washington D.C.
Oh, see, now that's a different conversation.
Yeah, some of the guys from Canada I know of had actually gone to D.C. or sent their filings into D.C. At the international office. So anyway, those things are available.
Okay, well, like I said, another time, another
Yeah,
conversation.
yeah, I'm just
Um,
about wore out here already. So
yeah, yeah. Well, it's really great having you come on and help us, bang around through the dark here
yeah,
because a lot of us a lot of the people are in the dark with a lot of this stuff. The last interview really enlightened a lot of people with what's going on.
yeah. And again, like I said, let me just advertise a little bit here, and that is if you go to my website, which is wwssiccom, which stands for Winston Shrout Solution in Commerce. If you want to go onto that website, we've also developed a YouTube. Eventually, this interview will end up there. But also, if you go down to the products list, all the things that I've talked about here are things that we have available on DVD form, along with templates and different things, that we've used. Since 2004, when I first came up under this Solutions in Commerce title. I mean, I was just commiserating with one of my buddies that's been with me, from the start, really. And we were just, kind of chuckling about the mountain of information that we've been able to put out. I mean, we've been at it now for 8.5, going on 9 years, or whatever it is. And the amount of information that we've accumulated, the technology that we've developed is monumental. And so if people want to delve deeply into, for instance, commercial liens, there's a single topic DVD devoted solely to commercial liens, along with the templates of various styles and applications and so forth. So, my recommendation, is to get educated. And, I mean, the talk and conversation we have on the air here and so forth is an indication of what can be done. And then people have to roll up their sleeves, get the information, study it, and then apply it. So, I'd recommend people to become educated, not just through me, but there's a lot of people that's put out, good information that's very helpful. And so my recommendation is, turn off that TV for a couple hours every evening and study. I was kind of joking with one lady here at the last seminar we did. She blamed me that she couldn't get any sleep. I said, why is that? She said, my husband and all his cronies sat up all night listening to your DVDs. And she said, I try to go to bed, but they keep it up too loud, laughing, they're carrying on. But anyway, a certain amount of time should be devoted, for those who are concerned with these issues and so forth, to study. And, if you was to apply an hour, 2 hours, or maybe 5 hours a week or something like that to study, you'd be well rewarded, to put it that way.
Yeah. And do you have any recommendations on some people they could go study as well, or books?
Well, it's all over the internet. I recommend to people to get as broad a spectrum as possible. Don't just believe what Winston has to say. Find out what everybody else has to say, and then and take the things that are most applicable to your situation. But like I say, we've been doing this since 2004. Gosh, I can't. I mean, the mountain of information that we've accumulated and passed on and so forth is tremendous. So anyway,
okay. Anything else you want to advertise? Any upcoming seminars or anything coming in the future?
I'm
DVDs.
I'm headed for Australia at the end of this month. I'll be back in August, and then we're going to have a webinar that's going to be devoted to an understanding of the exemption and how to use it. And that'll be presented, I think, probably the last weekend in August. You'll have to go on the website to see the exact date. But, I strongly recommend these webinars. They're on a single topic. They're directed. It's not like having a 2-day seminar. It's a one subject along with remedies and so forth. So yeah, go on the website and look at that. The webinar coming up, and I think we're anticipating toward the end of the year, perhaps November, to do a full-blown seminar. So those things are all advertised on the website, and with dates and conditions and all that kind of stuff. So yeah, go to the website, take a look at that. Look at the product list. For each seminar that we did, the subject matter that was discussed at that particular seminar is listed on that product list. So if you have a particular interest in a particular thing, you can go and look at that particular thing. Or
yeah, and then a DVD will be made of that Australia for those who can't make it to the Australia seminar.
No, that's going to be a private workshop.
Okay,
that's not an open seminar. But the webinar certainly is for public consumption, and any seminar certainly we do here in the States is wide open too.
So are you not allowed in Canada no more? You can't come up here and do any more seminars?
Last time I tried to get in Canada, they told me, they stopped me at the border and said, "Don't come back anymore. If you try it, we'll arrest you." So I don't come to Canada, but they can't stop the internet now, can they?
Sounds like a contract to me.
I thought about it for a while, but I had more important things to do than argue with them.
Didn't get arrested?
Well, it's not that so much. I knew that, if I went and took action on that, for instance, if I threw a $100 million lien on them, it would screw things up too much for them. I mean, up there in where it occurred in Vancouver or in BC, if I had to take action against BC, I knew they were on the ropes, as far as finances and everything. They're having a tough time of it. I mean, I think the whole economy in BC is actually funded by the marijuana that's grown on the island out there and transported into the United States. So, hey, I ain't kidding you. When they were holding me there, I was talking to that one enforcement officer there, about the marijuana problem. And one of those officers said, "Well, if you want some marijuana," he says, "just go down the street." This guy knew where to get dope at. He was standing right there keeping me out of Canada, telling me where to go there in Victoria to get dope. So I knew their economy must be hurting pretty bad, and I knew if I took a real decisive action against them for what they had done to me, it would only hurt the people. And so I said, "No, I'll just let that go." Like I said, we have the internet and everything. I mean, I don't have to physically be somewhere.
No, you could do like I could have run a seminar with you just on Skype right now with people there.
Sure.
Yeah. Okay. Well, I mean, we appreciate your time as always, Winston. We look forward to doing a follow up with some of the other issues that we come up with, and some other things like doing a writ. There's people who are interested in doing writs, and
cool. Okay.
maybe getting a little bit more into precipe.
Yeah, we would probably address some of those issues under the basis of habeas corpus.
Yeah.
So we could do that. Matter of fact, I do have a single topic DVD on habeas corpus if people are interested in that.
Well, there you go. There you go. Yeah.
Yeah, just go on the website. It'll be listed there under the products and stuff.
Okay. Well, we thank you again for coming on, and it's been great having you.
Okie dokie. We'll catch up again some other time.
Okay.
Thanks.
Okay. So.